Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello and welcome to this FedSoc Forum webinar call. Today, June 11th, 2025, we're delighted to host a Courthouse Steps decision program on Kousisis versus United States, which was decided recently by the court. My name is Kayla Feist, and I am Deputy Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, certainly more brief than her career would deserve, so I highly recommend that if you're interested, you check out her impressive full bio at fedsoc.org. Today, we are fortunate to have with us Brandon Moth, who currently serves as a partner at Wiley Ryan LLP, where she defends companies and their executives in complex civil and criminal cases involving alleged healthcare fraud, False Claims Act, whistleblower allegations, the Foreign Corrupt Practices Act, antitrust regulatory violations, and contract and procurement fraud. She has extensive experience shepherding life sciences companies, government contractors, not-for-profits, and technology companies through internal investigations and responding to subpoenas and civil investigative demands. And she also advises a broad range of companies on compliance programs, privacy, telecommunications, compliance, and new media issues. And I will leave it there. A last note, throughout the program, if you have any questions, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen. So they'll be accessible when we get to that extended portion of today's webinar. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Brandon, the floor is yours.
Thanks so much, Kayla. Appreciate it. Okay, let's start with this interesting case. So, Kousisis, in terms of black letter law, the 9-0 decision in this case is very clear and simple. Economic harm is not an element of the federal wire fraud statute. Simple, right? Taken a bit further, a defendant who induces a victim to enter into a transaction under materially false pretenses can be convicted of federal fraud, even if the defendant did not seek to cause the victim economic loss. However, while all justices subscribe to the black letter rule, it appears from the court's opinion and the concurrences that the justices fear that simple rule may create a slippery slope, a concern that perhaps is responsible for converting what could have been an 8-page opinion into a 20-plus page opinion, or 20-page opinion, accompanied by 3 concurring ones. Before we get to what the defense counsel and prosecutors might take from this copious dicta this case offers in addition to the rule, let's take a quick look at the underlying facts and the core holding. So, in the late aughts / early 2010s, the Pennsylvania Department of Transportation, PennDOT, solicited bids to renovate Philadelphia's 30th Street Station and Girard Point Bridge. The work was funded in large part by Federal Department of Transportation grants. The grants, like many federal grants, came with strings. PennDOT was required to establish and actively implement a disadvantaged business program. Of relevance here, PennDOT was required to set overall goals for disenfranchised or disadvantaged businesses for their participation in DOT-assisted contracts, meaning they were required to ensure that disadvantaged business enterprises, or DBEs, defined as a for-profit small business that is majority owned and controlled by one or more individuals who are both socially and economically disadvantaged, make sure that they have roles in the grant-funded work. Consistent with that rule, PennDOT required that the bids for these contract projects commit to subcontracting a percentage of the total contract amount between, 6 and 7% to a DBE. Kousisis, a project manager for the industrial painting company Alpha Painting and Construction, submitted bids, and Alpha ultimately won contracts for the projects. As part of the process, Kousisis represented in the bids that Alpha would acquire approximately $6.4 million in painting supplies from Marquesis, a pre-qualified DBE. But it turns out that wasn't quite true, and Marquesis was merely a pass-through entity. It turns out that Kousisis arranged for Alpha's actual paint suppliers to generate purchase orders billed to Marquesis. Marquesis received the orders, it tacked on a few percents, and then forwarded the inflated invoice to Kousisis at Alpha. He, in turn, issued 2 checks, one to Marquesis for the markup, and the other for the actual cost of the supplies. Brilliantly, the scheme was apparently memorialized in a letter of commitment. In addition to contradicting what Kousisis represented in Alpha's bid, this arrangement contravened DOT's rule that a contributing DBE perform a commercially useful function. Nevertheless, the scheme went undetected and Alpha performed the work, all the while falsely reporting qualifying payments to DBE. The work was completed satisfactorily and on time, which for many who've had painting work done may be amongst the most shocking facts in the case. PennDOT paid Alpha, and Alpha pocketed, it turns out, over $20 million in profit. Well, eventually, as one would guess, considering we're here, the lie caught up with Kousisis and Alpha, and they were indicted and found guilty of wire fraud and conspiracy to commit the same under 18 U.S.C. 1343 and 1349. In pertinent part, the wire fraud statute requires the government to prove that the defendant used wires to execute a scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. Post-conviction, the defendants moved for acquittal, arguing that notwithstanding the lack of DBE participation, because their paint work met PennDOT's expectations, PennDOT had received the full economic benefit of its bargain, and the government could not prove that they had schemed to defraud PennDOT of money or property as required under the fraud statute. This is an argument that found traction in about half the circuit courts that had previously considered it. Specifically, the 2nd, 6th, 9th, 11th, and DC had overturned convictions when it could be shown that the defendant did not seek to cause the victim pecuniary loss. Here, however, the district court allowed the convictions to stand, a decision ultimately affirmed by the Third Circuit, which joined the 7th, 8th, and 10th on that side of the split. Supreme Court granted cert and affirmed 9-0, holding that a defendant who induces a victim to enter into a transaction under materially false pretenses may be convicted of a federal fraud, even if the defendant did not seek to cause the victim economic loss. Justice Barrett authored the majority opinion. As noted earlier, the holding itself is quite simple and grounded in the statutory language. The wire fraud statute requires the government to prove that the defendant, first, devised or intended to devise a scheme, second, to obtain money or property, and third, by means of materially false or fraudulent pretenses, representations, or promises. Justice Barrett, relying on Webster's dictionary, posited that to obtain something means to gain or attain possession of it. And a thing is no less obtained simply because something else is simultaneously given in return. Accordingly, the court concluded that the wire fraud statute is agnostic about economic loss. And as applied here, the court affirmed because the petitioners devised a scheme to feign compliance with PennDOT's DBE requirement with the goal of obtaining money from PennDOT by making false or fraudulent misrepresentations. So, in sum, 1343 requires that money or property is the object of the fraudster scheme. It does not require causing financial loss or harm to another. This is a simple enough rule, and affirming the fraud in the inducement theory of liability, even when there is no economic loss, is in itself significant and could have ramifications, particularly for government contractors and grant recipients, given this administration's recent identification of federal procurement and government program fraud as criminal division priorities. However, the court's opinion doesn't end with the holding. Justice Barrett's opinion for the court goes on for another 12 pages to address and reject the defendant's various arguments, namely that not requiring economic harm is inconsistent with recent Supreme Court precedent, that economic loss was inherently in the fraud at common law, and that a loss requirement is necessary to prevent every misrepresentation from becoming charged with fraud. Simple and normal enough, right? Well, as it turns out, this is a case where the devil comes down to the details, and it appears that while all the justices were on board with the holding, not everyone is quite on the same page as to how it should be applied and what rules should be used to, delineate fraud that is subject to criminal prosecution from the fraud or civil misrepresentations in tort. Okay, so let's boil it down. Let's start with the opinion, then we can move to concurrences. First, Justice Barrett countered the notion that economic injury was a requirement of common law fraud, and thus in the soil with respect to the wire fraud statute, with examples, mostly civil, of cases where defendants were liable for fraudulently inducing transactions involving items that, while of equal market value, were not as described. Her standby here is an artfully described 1840 Maine Supreme Court case in which a seller represented to a potential buyer that he was selling the horse known as Charlie, all the time knowing that the horse he was selling was not actually the horse known as Charlie. The buyer exchanged a colt and $5 for the horse, which was not actually the horse named Charlie, but one seller claimed to be of equal or greater value. The court convicted under the false pretenses statute because the pretenses were false and induced the injured party to part with his property. Second, Justice Barrett made it clear that nothing in the decision was at odds with Simonelli versus United States, a 2023 decision that rejected a right to control theory of fraud. Put differently, a scheme to deprive someone of economic information necessary to make discretionary economic decisions doesn't count as a property fraud because fraudulent inducement doesn't treat mere information as a protected interest. It protects money and property. Here, the petitioner's scheme was not to undermine the DBE initiative, but to obtain money or property, e.g. the contracts themselves and the $20 million they eventually got through. Third, Justice Barrett eschewed the defendant's concern that every intentional misrepresentation designed to induce someone to transact in property would constitute a property fraud by highlighting the import of a fundamental element that, for whatever reason, went unchallenged in this case, materiality. Citing the demanding materiality standard articulated in Universal Health Services v. Escobar, a 2016 Civil False Claims Act decision, materiality was stated as the principal basis for distinguishing everyday misstatements from actual fraud and looks to the effect on the likely or actual behavior of the recipient of the alleged misrepresentation. At base, the key is whether the misstatement constituted inducement or motive to enter into the transaction. I'll stop here and just kind of reflect for a second about materiality. Again, it wasn't really something that had to be decided in this case. It wasn't an issue. It wasn't raised. The parties did debate the appropriate standard in their briefing, but at the end of the day, the court did not adopt one position or the other, but they did use the Escobar, as dicta and just as a standard to be used. So at base, while materiality wasn't challenged in this case, it is this articulation of the line distinguishing fraud that prompts a good bit of the subsequent debate, particularly Justice Thomas's concurrence and portions of Justice Sotomayor's rebuttal of the same. Okay, so at the end of the day, here with the opinion of the court, we have a straightforward holding based on statutory language that is unanimously adopted. Well, again, why do we have these three concurring opinions? At a high level, all three seem to be concerned with the precise contours of the line between actionable fraud and everyday misstatements. But then some go a bit further, with one seemingly embracing the materiality distinction and detailing how it could have been used in this case, had it been contested. Another criticizing the court's arguably indistinct line based on common law fraud and attempting to clearly cabin any future application. And a third eschewing any attempts to draw lines as beyond the scope of the case while also rebutting another concurring view's materiality comments. Let's take a look. First up, Justice Thomas, who wrote separately, purportedly to address an issue that the court reserved, whether petitioner's misstatements were material and thus actionable under 1343. As the court's opinion does, Justice Thomas, who perhaps not coincidentally was also the author of Escobar, referenced materiality as the, quote, principal basis for distinguishing everyday misstatements from actual fraud. He also acknowledged that, indeed, the petitioners did not contest that their representations were material. Nevertheless, he expressed skepticism that they were indeed material. And as we will discuss, his concurrence uses materiality as the launching pad to question the constitutionality of the DBE requirements themselves. Acknowledging that the court did not and need not weigh in on the appropriate standard of materiality in this case, perhaps for the purpose of argument, but potentially due to preference, Justice Thomas chose Escobar materiality, whether the misrepresentation went to the very essence of the bargain, to frame his concurrence and ultimate conclusion of skepticism that the DBE requirements were material to the contracts in this case, which were for bridge repairs, he pointed out, not minority hiring. The analysis bears attention because of its potential application beyond this case, and certainly something that FCA Defense Counsel will cheer. First, Justice Thomas shared his view that because the DBE provisions were irrelevant to the fundamental purpose of the contract, bridge repair, they were likely of the sort of minor and substantial conditions that cannot count as material. He also observed that if DBE conditions went to the essence of the bargains, the failure to meet those conditions presumably would have had some impact on the work product, and DBE conditions had no bearing on the petitioner's ability to complete their projects, a disconnect that tends to support the conclusion that those requirements would not meet the demanding materiality standards. I'm not much of a gambler myself, but I would easily wager a few bucks that citations to this language will appear in FCA dispositive motion briefings in short order. It's a great construct, even if only dicta. Second, Justice Thomas compared contract language indicating that failure to comply with DBE requirements may result in termination with language that required PennDOT to deduct payments if the work on the project was late or unsatisfactory, and concluded that the difference could amount to an indication that the latter went to the essence of the bargain, while the former did not. Third, referencing congressional and other reports of purported rampant DBE fraud, Justice Thomas questioned if whether the prevalence of such fraud could call into question whether the government actually considered DBE compliance to be essential to the contract. And fourth, in what may end up being a frequently cited portion of this concurrence, or at least talked about, Justice Thomas put forth a potential argument that the DBE provisions themselves are unconstitutional. And if indeed that was the case, they're unlikely to be material because it would be implausible to think that a reasonable person would attach importance to provisions that mandate constitutional violations. I'll steer away from the arguments for unconstitutionality and the hurdles Justice Thomas identifies as ones the government should clear to meet its burden. But Justice Thomas ultimately lands on the proposition that if the government cannot demonstrate the constitutionality of the DBE program, he doubts that the provision requiring compliance with the program could go to the essence of the party's bargain, particularly here, given that the same provisions requiring DBE compliance simultaneously prohibit discrimination on the basis of race, sex, national origin, or color. All in, Justice Thomas' position is that materiality, the demanding approach to which is all that prevents, quote, extraordinary expansive views of liability from rendering the federal wire fraud statute nearly limitless in scope, could doom the government's prosecution in DEB cases where materiality is contested going forward. Next, let's go to Justice Gorsuch, who concurred in part, and in the judgment, who wrote a concurrence that also focused on the line between a lie and criminal fraud. But instead of pointing to materiality, he focused on the injury requirement. In particular, Justice Gorsuch seems to be troubled by the court's purportedly dicta analysis of common law fraud and its indistinct injury requirement. He agrees that the wire fraud statute, like common law, has an injury requirement that does not demand proof that the victim suffered a net pecuniary loss. However, he takes issue with the court's assertion, particularly in a footnote, that the wire fraud statute's injury requirement is satisfied whenever a defendant obtains property that a victim would not otherwise have parted with by means of a material misrepresentation, as potentially too broad and risking turning victims' lies into federal felonies. For Gorsuch, lies without injury are not criminal frauds. His opinion uses the following example to illustrate the potential line drawing issues. Take, for example, a parent who is interviewing a babysitter to watch their child via phone. They ask her, whether she has a criminal background. The babysitter, knowing that she's previously been convicted of burglary about 10 years ago, and that conviction would probably disqualify her from the job, told them no. The babysitter is hired and performs the job well. After the fact, the parents learned the lie. Question then becomes, has the babysitter committed federal fraud? Fearing that a court applying common law materiality or the injury requirement could say yes, Gorsuch instead favors a requirement that the injury be demonstrated by proving that the defendant deprived his victim or her victim of what he bargained for. But while Gorsuch makes the point that common law materiality is no more principled than the injury rule, at base, in many ways, the benefit of the bargain rule that he suggests doesn't seem all that far removed from Escobar materiality. Indeed, Thomas references materiality as something that goes to the essence of the bargain. Essence of the bargain, benefit of the bargain, they're pretty close. Specifically, while Thomas and Gorsuch approach the issue from different directions, they seem to be looking at the exact same thing, more or less. Did the aggrieved party get what he or she bargained for? The concurrence also devotes not inconsequential real estate to making it clear that the portion of majority opinion with which he takes umbrage is dicta that goes well beyond the case. It states that nothing before us today turns on whether wire fraud's injury requirement demands proof that the victim did not receive the benefit of his bargain, or indeed proof only that he parted with money or property. Nor is adopting one rule over the other a necessary step towards the court's holding that pecuniary loss is not an element of fraud. Nothing in today's decision can bind the court in a future case where the difference between the two rules actually matters. And since he's looking forward, he wants to make sure that the broad rule articulated by the court doesn't get applied in a way that assumes as true and negative. Finally, let's turn quickly to Justice Sotomayor's concurrence. The headline here is that she, like everyone, embraces the court's core ruling, which, as she puts it, is when a defendant tricks a victim out of their money by promising one thing and delivering something materially different, it is no defense to say that the delivered items are of equal economic value. However, the justice would have stopped there, noting that straightforward rule was all that was needed. And to the extent the majority appears to speak more broadly, she disagreed with their approach. Because resolving the economic loss theory resolves the matter, she sees no reason for the court to opine on different types of fraudulent inducement cases, including ones where the defendant provides exactly the goods or services that they promise to deliver by lies in other ways to induce the transaction. Acknowledging that there is a debate, she rests on the position that future cases presenting such fact patterns will require the court to confront the outer limits of the federal fraud statute's reach and decide what satisfies the materiality element. But this is not the case here. And in theory, that should be it, right? She disagrees with the rest of it. Here's the rule. Not so fast. The justice then decided to take the opportunity to critique Justice Thomas's concurrence. Justice Sotomayor argues that there can be no dispute that the misstatements were material. While she is correct in that they weren't contested in this case, it is a curious thing to say here, given Justice Thomas's concurrence does raise several points exactly to that effect. I'll leave her specific counters to items Justice Thomas identified to the side for now. But in sum, the crux of her materiality argument seems to be that if the requirements were not material, they wouldn't have lied about it. The defendants wouldn't have lied about it. You don't really come up with a big scheme and, pay someone for work that they're not doing when it's not material. So all in, where does that leave us? It's clear that this decision does resolve a circuit split. Fraud in the inducement is a viable theory of fraud, and economic harm is not an element. It's less clear where the court will draw lines when it comes to the difference between the statements made during transactions, e.g. a car dealer trying to catalyze a sale by falsely representing that someone else is coming to look at the car, and actionable fraud. The majority, including seemingly Thomas and Sotomayor, appear to look to materiality. However, the specific contours of materiality in this context have not been defined, and it's not clear how it might be applied to various fact patterns. perhaps recognizing the difficulties inherent to a neutrality decision and its nexus with an injury requirement, Gorsuch would favor something akin to a benefit of the bargain analysis, which in theory could also be part of materiality. At the end of the day, this case leaves a reader wanting more, specifically another opportunity, a different fact pattern that the justices could use to draw critical lines capping fraud. However, whether or not the court emerges from this decision with such a desire is another question altogether.
Well, thank you so much for that summary, a really excellent summary of the case, how we got here, and then not just the overall holding, but the pieces of each of the opinions. That was very helpful. As we transition into our time of question and answer, I'll issue a reminder to our audience that if you do have questions, you can submit those via the Q&A feature. And as those come in, I'd love to kick things off with a couple of questions of my own. Starting with some general questions on the nature of the opinions and sort of the argumentation throughout. Was there anything in the opinions that surprised you to see, either questions or lines of argument that was surprising to see come up?
Well, I'll say I was surprised that we got this many pages of words about a decision that's 9-0 that is, it's a pretty simple proposition that's based on the text of the statute itself. There are some interesting discussions. The common law, of course, is always interesting to look at. It does seem like they're kind of dancing on the head of a pin in some situations, but I can get where that's important because facts matter in these cases. And if you come up with one rule, it can easily be taken to mean something else depending on the facts. Justice Thomas's concurrence was surprising in some ways, not surprising in another. He's always been one that cares deeply about neutrality. He is the author of Escobar, and I'm always fascinated to hear what he said. I mean, considering a lot of my work right now is defense of False Claims Act cases, I gotta say it's something that brings a smile on my face to read through. Yes, it's dicta. I think it's really compelling, but to see how he's thinking about these things, it does kind of inspire me to come up with some new arguments and potentially apply them. It would be fascinating to see if some of these things actually boil up, and maybe he's inviting them to come up.
Touching on that, I know you mentioned this in sort of your closing out comments. Do we have a clear sense with this decision of what parts are dicta, what parts are going to be not truly binding, but treated as binding in future conversations and interpretations? And I ask in part because of Justice Thomas's concurrence and the way it was in conversation, not just with the majority, but also with Justice Sotomayor and hers.
Yeah, so it's clear that the holding is the holding. And that's pretty simple. Mm-hmm. Yeah, you can have a fraud and inducement case, and no, it doesn't require a showing of economic loss, period. That's it. I do think the justices might disagree a little bit about what else may or may not be dicta. But the disagreement might not be as broad as one would think. Gorsuch seems to think that the court's opinion creates a broad rule that could be misinterpreted and calls it dicta because it's not necessarily germane to the facts of this case. Justice Barrett doesn't necessarily agree. In fact, she says it's not dicta because it's inherent in the rule she's saying. Looking at footnote 5, I think she says specifically that, let me dig it up really quickly. I apologize. So going back to it, Gorsuch takes aim, characterizing it as not reflecting a rule under the federal wiretap statute or wire fraud statute. It doesn't matter if the punitive victim receives all he was promised so long as he parts with any money or property because the defendant's misrepresentation. That's injury enough to sustain a federal wire fraud conviction. That's what he's afraid of. And he argues that's not what it was, common law, and risks turning a misrepresentation into fraud. But if you look at the actual footnote that he's taking the issue with, it just is that, while they all agree that the injury is required, the injury need not consist of economic loss because the obtaining of the money or property by false representations is what amounts to the perpetration of the fraud. It further addresses Gorsuch's point that the position is dicta. She says that because to reject that pecuniary loss as an element of fraud is to necessarily accept that, as common law courts long have, that fraud is complete when the defendants have induced the deprivation of money or property onto the materially false pretenses. So what she's saying is that the rule is not dicta. It's just inherent to the bigger part of the rule. It's for them to come in later and flush out more limitations.
Got it. Thanks so much. Turning to the sort of opposite of the question I'd asked earlier, you said, hey, it was slightly surprising that we got so much and there was such variety, even with a 9-0 decision. Was there anything that was surprising not to see come up in any of the opinions?
Anything surprising not to see? It is interesting that they didn't go, and somewhat unfortunately, that they didn't adopt a clear role of materiality. It seems like they're all kind of on board with Escobar, more or less, but they don't say it. So that makes it hard to apply it going forward. And you understand why it's not in here. It wasn't an issue in the case. It conceded materiality. But if you're going to say materiality is a limitation, then you should probably say what materiality is.
Got it. Looking at the potential ramifications of this case, and you called this out a little bit in your summary, Justice Thomas highlighted his concern that the disadvantaged business enterprise quotas, particularly as currently applied, might be unconstitutional in and of themselves. To what degree might that line of argumentation affect the way future misrepresentation cases / wire fraud cases are argued? And does the door seem to be open to arguing that those aspects of the contracts are unconstitutional or not valid?
Oh, absolutely. I mean, given what he said, obviously it's not binding, but it would make a lot of sense if you're fighting a False Claims Act case, let's say saying misrepresentations of 8A or other programmatic fraud, using disadvantaged businesses, or there's a lot of small business type requirements in these contracts that you wouldn't raise that kind of concern. Now, whether or not it wins the day is a totally different question. But yes, if you're litigating it, then there are a lot of reasons to consider that as an argument.
Got it. We actually have an audience question that follows up on that train of thought. The current federal administration seems to want to enforce some grant conditions and is calling others into question, much like Justice Thomas did in his concurrence. How could this decision play out in the current administration's approach over the next couple of years? How might they interact?
Yeah, it's a great question, one I was thinking through myself, because in some ways it could cut both ways. I mean, the key here is that it's dicta, it's not controlling. But the thoughts behind it are fascinating. Of course, on one side, you have this whole unconstitutionality argument with these set-aside programs. On the other hand, you have Justice Thomas reiterating his belief that just because you're conditioning money on performance of certain things doesn't mean that the performance or the compliance with those requirements is material to a contract. There are different ways the administration could parse that. They could, be even clearer about why things are material. They could, the more you say about it, the more it is. They could stop payment on programs if they find out that they're non-compliant. There are different ways to shore it up. It's going to be very, very fact intensive at the end of the day, but it does raise some interesting questions.
Got it. Looking a little more at the other areas of law that might be affected by this, is there a sense of what downstream effects of this decision there could be, either in this area of law or elsewhere, and what other industries or areas of law should be paying attention to the argumentation, both for the central holding, but also for the variety of arguments that were put forward by the justices?
Yeah, sure. I mean, obviously government contractors are going to be right up there. This is clearly on all fours for them. There's clearly a sanctioned fraud and inducement theory that's going to go forward. Government grant recipients are totally involved in that too. I think the False Claims Act, in some ways, not necessarily the holding itself, but some of the dicta and Thomas's constructs could be impacted or influenced by it as well. But I mean, when it comes down to it, it's going to be fun to watch what happens to cases going forward. This court has shown a proclivity for narrowing fraud. And I think they might look for opportunities to do that going forward with cases based on specific facts. That being said, maybe they were surprised by the debate that they got with this one, which should have been, in theory, pretty straightforward. So maybe they won't be inclined to take more.
Got it. Are there immediate impacts? I probably should have started here for Kousisis and Alpha. Is this the end of the line in their conversation, or does the fact there was a materiality conversation between the justices, but not something they granted, leave that door open for them? That's a fact issue in this particular case, but since it's so fact bound.
Yeah, and I think what you're asking is can they go back and litigate the materiality issue? Is that right?
Yes. Yeah. Well, that continued the conversation that the justices seem to want to have, even though the case didn't necessarily present it.
And that's a great question. And with the disclaimer that I haven't read all the pleadings, the trial transcripts, I don't know what evidence was put forward. I don't know what statements were made. Really, I'm relying entirely on the SCOTUS characterization of the state of play. I think it could probably be tough if they truly waived it and said that it was material. That's kind of what it is. That being said, I don't want to say no because, criminal defendants are often given more leeway and opportunities. And Justice Thomas's concurrence could theoretically provide some momentum.
Got it. Well, looking then to the questions that remain, and you've highlighted some of these, and now that we have a decision, what are the questions that are outstanding and unanswered?
Yeah, I think it has to be the contours of the injury requirement. What kind of injury is required? What is it precisely that turns an everyday misrepresentation into fraud? Just because I say I'm selling you a Marigold school bus and you buy it for X amount, I give you a bus that's worth X amount, but it happens to be highlighted or yellow, is that a material misstatement? Is that fraud? And I think that's where the rubber hits the road for some, especially Justice Gorsuch. It's a hard question to answer. It's one that will require a lot of thought. But I do think that they're coalescing around this benefit of the bargain type agreement. And now how they explain it, that'll be interesting to watch, but it should fall somewhere in there.
Got it. Well, we may be able to wrap early and give people a section back of their days, but I'll turn it over. Do you have final thoughts or something you'd like to leave us with?
No, it's a fascinating case in some way because it's surprising that this much ink was spilled. That being said, once you really dig into it and you see what the arguments are, they're fundamental to what fraud is. I'm excited to see if they take another case like this. Part of me says they probably won't, given the amount of back and forth they've had. But if they do, obviously facts matter more than anything else in fraud cases. But I'd be excited to see where they go.
Sounds good. Well, thank you so much for taking this section of your day and sharing your expertise and insight. The breakdown of the opinion and the cases, or the case and the opinions, was really, really helpful in understanding the back and forth and how a 9-0 had so many pages devoted to it. It certainly is an interesting read, and this is a lot easier to read with that background. So thank you. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website, your emails for announcements about other upcoming virtual events. With that, we can adjourn a little early. Everybody can have a section of days back. We are adjourned.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federalist Society's practice groups. For more information about the Federalist Society, the practice groups, and to become a Federalist Society member, please visit our website at fedsoc.org.